The following presentation are general rules which can be applied to property upon dissolution of a marriage or for purposes of a partition and exchange agreement or for a probate matter. The rules as I present to you are based on Texas case law and the Texas Family Code. Marital property in Texas. Property owned by a spouse is marital property. Marital property is either separate property or community property or a mixture of the two. Property not owned by a spouse is not marital property and is neither separate nor community property. Inception of title. The character of marital property is separate or community or mixed, is determined at the time of inception of title. Inception of title occurs when a party first has a right of claim to the property by virtue of which title is finally vested. Property that is acquired before the marriage is separate property. Property acquired during the marriage is community property with the following exceptions. Property that is acquired by gift, by devise or descent, by partition or exchange, as income from separate property made separate by a spousal separate income agreement, by survivorship in exchange for other separate property, as recovery for personal injury sustained by the spouse during marriage, except in recovery for loss of earning capacity during marriage. This last rule would apply to the extent that you had a accident, and as part of that accident you received a bifurcated claim both for lost wages and for pain and suffering. The pain and suffering would be separate, the lost wages would be community. Property acquired after dissolution of marriage, property which has the inception of title after the marriage is dissolved, is not community property. There is a presumption of community property, and that property possessed by either spouse during or on dissolution of marriage is presumed to be community property, and the separate property character must be proved by clear and convincing evidence. Co-mingling is when separate and community property have become so commingled as to defy resegregation and identification. The burden of persuasion to overcome the presumption of community is not discharged, and the assets in question are treated as community property. Tracing involves the tracing to the inception of title. The character of separate property is not changed by the scale, exchange, or change in the form of separate property. If separate property can be definitely traced and identified, it remains separate property, regardless of the fact that the separate property undergoes mutations or changes in form. Tracing involves establishing the separate property origin of the property through evidence showing the time and means by which the spouse originally obtained possession of the property. The best example I can give you as to mutations of separate property would be in a 401k in which you're trading ETFs or stocks. If you take the balance on the date of the marriage and treat that as separate, and then the balance on the date of divorce, and the divorce is relatively quick with the marriage, maybe 2 years later, and you have a stock market that has had large increases, but your characterization as far as the underlying assets were not traded and they just increased in value. Technically, you would have all separate property if you had, whether it's stock or ETFs in Apple, and the prices, the cost, the value of the stock on the day of the marriage was, say, $110 per share. On the day of the divorce, it was $130. That would not be treated as a community asset. That would still be a separate property asset. However, the burden is on you to trace that, to show that your underlying 401k, the assets in the 401k were not changed in form through buy and sell and otherwise mutated with growth to then become community property. This is where the co-mingling comes in. Divestiture of separate property in divorce. In a divorce, a court cannot divest a spouse or either her or him of their separate property. Increases, decreases. The natural increase or decrease in the value of a separate asset does not affect its characterization. Credit obtained during marriage. Credit obtained by a spouse during marriage is community credit unless the lender agrees to look solely to a borrower's spouse's separate estate for repayment. Property acquired with community credit is community property, and property acquired with separate credit is separate property. Credit during marriage is presumptively community, and the burden is on the proponent to prove separate credit. Even property acquired with community credit can become separate property by interspousal gift and partition. Presumption arising from deed recitals. When a deed recites that separate property was paid for the property, or that property is taken as a receiving spouse's separate estate, a rebuttable presumption of separate property arises, where the other spouse is grantor or otherwise chargeable with causing or acquiescing in the recital. The presumption becomes irrebuttable absent fraud. Presumption arising from interspousal conveyance, where one spouse conveys property to the other spouse, there is a rebuttable presumption of gift, even absent a recital in the instrument of conveyance. Presumption from including other spouse's name and title, where one spouse furnishes separate property consideration and title is taken in the name of the other spouse, a rebuttable presumption of gift arises, where one spouse uses separate property to acquire property during marriage and takes title to that property in the names of both spouses. A rebuttable presumption arises that the purchasing spouse intended to make a gift of one half of separate property interest to the other spouse. Presumptions regarding income from interspousal gifts, where one spouse makes a gift of property to the other spouse, that gift is presumed to include all the income of property which might arise from the property given. Presumption regarding withdrawal of commingled funds, where an account contains both community and separate monies, there is a presumption that community monies are withdrawn first. Putting separate property money in a joint account. The act of placing separate property funds into an account under the control of both spouses does not make the funds community property. Fixtures. Under the law of fixtures, whatever is affixed to the land becomes part of the land. Improvements to realty take the character of the land regardless of the character of the funds or credit used to make the improvements. Corporate assets. A shareholder owns shares in the corporation and not assets of the corporation. Corporate assets are neither separate nor community property unless the court pierces the corporate veil. The increase during marriage in value of separate property corporation belongs to the separate estate. Partnership rights of a spouse. Under the Texas Uniform Partnership Act, there are 3 property rights of a partner. 2 of these cannot be community property. One can be community property, the partner's interest in the partnership. Partnership assets and partnership distributions. Texas has adopted the entity theory of partnerships. Partnership property is owned by the partnership and not the partners. In the absence of fraud, it is not the separate or community property of the individual partners. If a partner receives a share of the profits during the marriage, they are community, even if the partner's interest in the partnership is his separate property. Trust holdings and distributions. Property held by a trustee for the benefit of a spouse is not owned by a spouse and cannot be marital property. At the same time, where the spouse beneficiary has an unconditional right to have the property free of trust, then the property is treated as if it is owned by the spouse, even though still in the hands of the trustee. Where the spouse is both the settlor and the beneficiary of the trust, the income of the trust property is likely community income. Where the trust is established by gift or will, case law is conflicting as to whether the trust distributions are separate or community. Presumption of Texas marital property law. Federal law sometimes preempts Texas marital property law. In those circumstances, the federal law must be consulted to determine the rights of spouses and the property in question. This is frequently comes up with Social Security. Social Security is characterized as separate property and not partitionable. Many times in a divorce, one will look to Social Security as an asset and attempt to set up that income stream as a future asset, and they'll try to argue it. Usually that's shot down very quickly. There are certain employee benefits as to retirements and the characterization of those retirements, which are broken down into defined benefit plans, defined contribution plans, and stock option stock plans. A participant's spouse will have a separate property interest in a defined benefit retirement plan equal to the monthly accrued benefit the spouse had a right to receive at normal retirement age as of the date of the marriage, regardless of whether the benefit is vested or not. The community property interest will be determined as if the spouse participant began his or her participation on the day of the marriage, regardless of whether the benefit was vested. A defined contribution plan, the separate property interest of a defined contribution plan may be traced using characterization principles in regard to non-retirement assets. Stock options, stock plans, the separate or community interest in employer-provided stock option plans are determined using a formula set forth in a statute. So the formula again involves the tracing, and to say that on the date of a marriage that is your separate property, when during the marriage the underlying assets only increase in value, that is going to require you to hire a forensic certified public accountant. And for the most part, if you do that and you maintain the same asset, but the asset grows in value, many times you can still prove that as your separate property and it's not subject to partition. Insurance proceeds, casualty lost insurance proceeds take on the character of an asset that suffered the casualty. Disability payments and workers' compensation payments are community property to the extent there are payments to replace earnings during the marriage. If they are payments to the participant that are made while the participant is not married, then they are separate property. The rules, as I read them to you, are general rules, and I would tell you to seek the advice of an attorney if you are in a marriage dissolution situation. But this gives you an idea of the application of the rules by giving you general concepts based on Texas case law, for which with your attorney you may strategize as to the value of your estate and perhaps the hiring of other professionals to help you in tracing any assets that could be traced. My name is Michael Busby. I'm a Houston family law and divorce attorney.